This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we speak about a fraudulent claim of injury defeated by a full investigation by the defendants, and why a failure to respond to a motion for summary adjudication will always lose because there is no defense presented. The plaintiff appealed from two orders granting summary disposition in favor of the defendants, an accident perpetrator and an insurance company, even though he failed to respond to either motion. In Chris Calco versus Melissa Lynn Pugh and Precise MRI of Michigan, LLC versus Citizens Insurance Company of the Midwest, the Court of Appeals of Michigan on October 30, 2024, affirmed the trial court's decision. The case arose out of a motor vehicle accident that occurred on March 9, 2020, involving the plaintiff and Pugh. Plaintiff alleges that he sustained injuries from the accident. A year after the accident, plaintiff brought a negligence claim against Pugh, alleging that because of Pugh's negligence, plaintiff sustained severe permanent and progressive personal injuries and serious impairment of a bodily function, including but not necessarily limited to head, neck, back, shoulders, etc. Plaintiff also brought a claim against Citizens for PIP, that's personal insurance protection or no-fault benefits, including medical expenses, work loss, and replacement services. Pugh and Citizens moved for summary disposition, arguing the plaintiff could not meet his burden of showing that he sustained a threshold injury under the No-Fault Act, and therefore he could not maintain his negligence claim against her. Pugh submitted the deposition testimony of the plaintiff and the report of an independent medical examination conducted by James Bregman, MD, on December 27, 2021. Dr. Bregman further observed that plaintiff had near full range of motion in his neck and that he was eminently capable of standing and touching his toes despite his refusal to do so. Dr. Bregman noted that plaintiff had very little medical treatment documented in his records and that he had been undergoing physical therapy for 6 months with no medical basis for doing so. An investigator's report included pictures of plaintiff walking, riding a child's bicycle, squatting, bending over, lifting a bicycle out of a minivan unassisted, playing with a dog, driving a car, and twisting his neck. Citizens' motion argued that plaintiff made material misrepresentations to Citizens regarding the extent of his injuries, which rendered him ineligible for benefits. Basically, fraud. The trial court found that based upon the evidence presented, plaintiff failed to establish that he sustained a serious impairment of bodily function, and therefore summary disposition in favor of Pugh and Citizens was appropriate. The threshold injury required that plaintiff show by evidence to the court disposition in favor of Pugh was improper. Under the no-fault statute, the threshold question of whether the person has suffered a serious impairment of bodily function should be determined by the court as a matter of law as long as there is no factual dispute regarding the nature and extent of the person's injuries that is material to determining whether the threshold standards were met. Plaintiff was obligated to respond to Pugh's motion in order to meet the burden of demonstrating that a fact question existed as to whether he suffered a serious impairment of bodily function. The parts of plaintiff's deposition identified by Pugh do not establish a genuine issue of material fact as to whether he suffered a serious impairment of bodily function. The relevant portions of plaintiff's deposition testimony failed to rebut the evidence and instead set forth at best mere subjective complaints of pain. The fraud statute relied upon by the insurer finds that a person who presents or causes to be presented an oral or written statement knowing that the statement contains false information concerning a fact or thing material to the claim commits a fraudulent insurance act under that is subject to the penalties imposed under the statute. A claim that contains or is supported by a fraudulent insurance act as described in the statute is ineligible for payment of PIP benefits. And an individual commits a fraudulent insurance act when 1. The person presents or causes to be presented an oral or written statement. 2. The statement is part of or in support of a claim for no-fault benefits. And 3. The claim for benefits was submitted to the appropriate agency. Further, the person must have known that the statement contained false information and that the statement concerned a fact or thing material to the claim. The plaintiff knew there was such a fraudulent statement. The court concluded it existed, and therefore there could be no claim owed by the insurer. In my opinion, the evidence presented by the defendants were damning, since they established the injuries claimed were false. Plaintiff failed to respond to the motions to his detriment and sought reconsideration without any admissible evidence that he was truly injured. The defendants established that the plaintiff committed fraud, and he is lucky that this was a civil finding, not a criminal proceeding that, in my opinion, should be presented to the prosecutor. This video was adopted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. If you do, you'll receive notice of every blog posting, usually 5 or 6 a week, and you will also gain access to the more than 4,900 blog postings. You can also subscribe to the videos on YouTube and rumble.com. They're all free. And if you do, please click on the like button on YouTube or the thumbs up button on rumble.com. Please tell your friends and colleagues about this blog and these videos so that they too can subscribe. And if you're interested in obtaining information more detailed about insurance, insurance claims, insurance law, and insurance fraud, please consider for a very small fee subscribing to my Substack publication. Thank you for your attention.